like to make a few bridging comments after listening to Heather McDonald's presentation, which I would refer to as the perversity of statistics. And obviously, the law is going to come to the rescue, maybe. Also listening to her, I was reminded of my own graduation from the better high school, not Stuyvesant, but from Brooklyn Technical High School, which was a competing magnet school in New York City. And I got into Columbia, not because of my grades or my SAT, but because I was an athlete. I was in fencing. And so I don't know how to fit in myself into this statistical model. Fast forward, I got into University of San Diego in law school as a diversely qualified applicant. And you might look at me, why is he diversely qualified? Well, it was not because I had my PhD in anthropology, but because they looked back to my college grades back in 1965, and I was only a B-minus student at best. So I was a late bloomer. And so we're addressing issues to me that how did we get here? And how do we get out of this particular problem was quite vividly presented by Heather's looking at not only crime, but also skills gap. And here, I guess, it really responds to the educational system that we do have a skills gap, and we do have some new legal frameworks to kind of address that, but seemingly doesn't do a good job at that. And part of it is because I don't think, speaking again as a cultural anthropologist, you cannot really address removing barriers to equality when there is those disparate realities in the world. So something else is really needed. So we're going to look at one side of the problem. And unfortunately, we really need to look at both sides concurrently. So with that in mind, we'll do the best we can. So in the SFFA versus Harvard and North Carolina Chapel Hill cases, Chief Justice Roberts wrote, eliminating racial discrimination means eliminating all of it. Possible? So that we have a gold standard there that we're going to talk about. And Justice Thomas added that the Constitution prevails. So again, we're going to look at that possibility, not only in terms of federal standards, but also within what we talked about earlier in terms of Prop 209, in terms of California law, both federal and state frameworks for dealing with the problem of discrimination. I'll give a short introduction of Jack and Andrew here. Jack Brown worked with Pacific Legal Foundation attorneys to defend individual liberty from governmental overreach and abuse. Learning about the principles of individual liberty inspired him to pursue a legal career protecting those principles through public interest litigation. Andrew Quinio joined Pacific Legal Foundation's Equality and Opportunity practice to make sure that no government denies any person the equal protection of the laws. Andrew became devoted to liberty after seeing how his immigrant parents achieved the American dream by having the freedom to prosper and the right to keep what they worked hard for. So I'm going to, instead of dividing up the questions as was initially planned, I'm going to ask all the questions together so that they each can give their overview in terms of how they work together and then comment on each other's presentation. So let me provide you with those questions. The first, does the Supreme Court ruling have wider implications for areas other than higher education? How can we frame constitutional neutrality and equality in public discussions on race, as well as future legal pursuits in defense of equal justice? And I would add, in terms of the earlier discussions, that we find that there are workarounds proposed by the progressive wing, such as ACA 7. So we're always having to compete with those workarounds as opposed to really framing the discussion in terms of these gold standards that we have. So I'd like the presenters to address not only the broader framework, but the constant attempt to undermine them and how we might forestall those attempts. So Jack, do you want to?
Sure. Well, thank you all very much for having me. I really appreciate it, and it's good to be here at CFER's annual conference. We at PLF have really valued our partnership with CFER in fighting for, in fighting for equality under the law, it's been really fruitful, and we hope to continue to do so. As far as the question goes regarding the Students for Fair Admissions case, the case does indeed have wider applications in areas other than higher ed. As a matter of fact, lower courts, just within a few short months of the SFFA decision, already started applying that decision to areas other than the college admissions process. In Ultimate Service Corp, the U.S. Department of Agriculture, the Eastern District of Tennessee held that SFFA's reasoning is not limited to college admissions, but it is also applies to business development programs such as MBE programs or other programs that are designed to favor small businesses or minority-owned businesses in government grants. And the Southern District of Texas made a similar holding in Landscape Consultants of Texas v. City of Houston, which was a similar challenge to a subcontractor requirement for minority business enterprises. And it's even had an impact on our own representation of CFER fighting for equal rights in California. For those of you who may not be aware, we have been representing CFER in the case CFER v. Alameda County. Now, at issue in the case was that we were representing CFER and two concerned California taxpayers, Chunhua Liao and Debbie Ferrari, who some of you might know. And it was a challenge to Alameda County's discriminatory contracting programs, which required prime contractors on specific government construction contracts to subcontract 15% of the dollars to minority business enterprises, which is a category of businesses that is determined based on the race of the business's owners. Now, shortly after we filed the case, the county filed what's called a motion for judgment on the pleadings, which basically argued that the case should be dismissed, arguing that our claims were time barred. They said that because they started discriminating on the basis of race more than 4 years ago, they should be allowed to keep doing it. Now, for those of you who may not be familiar with the ins and outs of the law, that's not really how the statute of limitations works. Because in this particular case, it wasn't, to paraphrase C.S. Lewis, these programs were not something the county had done. They were something the county was still doing. And you can't be time barred to challenge something that the government is still doing. So we opposed the motion for the judgment on the pleadings on that basis. Now, the trial, and it would leave ongoing illegal conduct unable to be challenged as long as the county got away with it for a few years. Now, unfortunately, the trial court actually bought this argument by the county. They said that, or the trial judge said that, well, the programs were in full view of everyone, and so on that basis, you can't, you don't have any excuse for delaying your challenge to these programs, even though I think at least in the case of one of our clients, they would have been 4 years old when the programs were enacted. It's an absolutely ridiculous argument, and fortunately, the First District Court of Appeal for the state of California recognized the absolutely horrible implications of the county's position, and they rejected it. They said that they did not rule on the merits of whether or not the programs were discriminatory. That wasn't the issue before the court, but they did say that assuming that the programs were illegal, then they represented an ongoing constitutional violation, and therefore they were not time barred. Now, this created a bit of a pickle for Alameda County, because having lost on this procedural issue, they knew that they were now going to have to defend these two programs on the merits. And under the Equal Protection Clause, they would need to satisfy what's called strict scrutiny, which is a very high standard to satisfy. You need to prove that your race-based measures serve a compelling government interest, which in the contracting context means that you're trying to remedy past discrimination on your part. And on top of that, your race-based measures have to be the least restrictive means possible to fulfill that interest. Otherwise, it's unconstitutional. Then on top of that, of course, it also there was also a challenge under Prop 209 that just says that racial preferences, even if they can survive strict scrutiny, are still illegal. So they knew they were going to lose on the Prop 209 issue, and they were probably going to lose on the 14th Amendment issue. So a couple of weeks ago, the Alameda County Board of Supervisors repealed the programs as a result of our lawsuit and the SFFA case. County Council told the board that, having lost in the appellate court on their statute of limitations argument, this litigation setback and the overall state of jurisprudence in the field warrant stepping away from the programs. The holding and analysis in the recent decision of the U.S. Supreme Court in Students for Fair Admissions has been interpreted as extending to race and gender-conscious programs like the one SFFA challenged. Recognizing these legal impediments, staff recommend that the programs be repealed. And that's what they did. Thank you. So the future is very, very bright for the fight for equality and opportunity in California and abroad, in no small part due to the Students for Fair Admissions case. And Students for Fair Admissions represents the kind of fulfilling the promise made by the Declaration of Independence that all men are created equal and that you're all entitled to life, liberty, and the pursuit of happiness. As Frederick Douglass recognized, there is only one principle that gives peace, strength, and security to the Republic, and that is the principle of absolute equality under the law. That message is a unifying one, and it's one that I believe will carry the day in future equality fights. Thank you.
Just a few things to add to that, and I want to also extend my thanks to SFFA and all of you for allowing me to substitute for Professor Sander. The role of Professor Sander will be played by me this afternoon, a poor man's version of him. If you get a chance after this to look up some of his work, please do so. He is brilliant. I have gone to him on many occasions for advice and to collaborate with him on some of the things that we've been doing. So I'll do my best to replicate, albeit poorly, some of his massive intellect. But to emphasize what Jack was alluding to, the Students for Fair Admission decision is a big deal. Don't let anyone make you think otherwise. And I want to emphasize, and it's certainly not lost on this crowd, how big of a deal it is. And I can emphasize it as much as I can without using curse words because it's such a big deal. And I remember last year when we were at this conference, and we were just, I think, a month after the court had released that decision, and we were all very optimistic and very hopeful for the future, and we had good reason to be, because what the court decided in that case reverberated for so many things where government was attempting to discriminate against individuals based on race. And so don't let anyone tell you that that case can only be restricted or applied to the higher education context. It applies to anywhere where government is trying to use its power to treat people differently based on race, ethnicity, skin color. The 14th Amendment doesn't say that no state shall deny individuals equal protection of the law only in or related to higher education or educational institutions. It applies to government power. And ever since then, we have been robustly using the decision in Students for Fair Admission to go after any instance where government is discriminating. And I'll give you 2 examples in addition to the ones that Jack laid out. In Minnesota, shortly after the Supreme Court gave that decision, Minnesota had a grant program for farmers, for emerging farmers. These are younger farmers who had not been farming for a long time, and they were providing them assistance through grant funds to buy their very first farmland. And the way the process worked was you would apply for this grant, and you would be randomly selected from a lottery to receive this grant money. But then, after you're selected from the lottery, your order in that lottery would be rearranged based on your race and your gender. If you were a minority or female farmer, you would be pushed up in those rankings and have a greater chance of getting a grant. So we had a client by the name of Lance Nistler, who's a young farmer, eligible for this grant. He was selected, I believe, 9th in the lottery. And so when he applied, he was initially one of the first few people to be selected to get this grant. Under normal circumstances, without the discriminatory preferences, he would have gotten this grant fund and he would have been able to buy his first farm. But because he didn't identify as a person of color or as a female, he was pushed to the very bottom of not just the grant recipient list, but the wait list. So needless to say, he didn't get the grant. So we sued on his behalf. We sued who's now the vice presidential nominee for the Democratic Party, Governor Walz. And shortly after we filed that lawsuit using the language of the Supreme Court decision in Students for Fair Admission, the state of Minnesota changed that program. They removed the racially preferential criteria in that program. So now you don't have to be a farmer of color or a female farmer to have an advantage in getting that grant. Another similar case we filed in Oregon. Oregon had a program where teachers could get reimbursed for renewing their teaching licenses or getting a new teaching license. Of course, the gimmick was you would only get that reimbursement if you were a diverse educator. Well, how did they define diverse educator? Diverse educators were only those that were persons of color or female or were linguistically diverse if English was not their primary language. We had an educator who had been teaching Spanish, high school Spanish, for a little over 30 years. Of course, because he was a white teacher, he could not get that reimbursement. And I always like to emphasize that you know he's a teacher that teaches Spanish. He's not a Spanish teacher. If he was a Spanish teacher, he would have actually gotten this reimbursement. But he teaches Spanish. So we filed the lawsuit against Oregon, and same thing like in Minnesota. Very quickly after we filed that lawsuit, Oregon backed away and changed that program. They got rid of that program, and now they're not discriminating against teachers for reimbursing their licenses. So all of these examples and instances are indications that the Students for Fair Admission decision does have power behind it. We can use it effectively. We have a great opportunity with a favorable Supreme Court, with that favorable decision, to really start reversing the deep history of government discrimination that we have been seeing for the last few decades. One important thing that it did is it deflated the importance that government discriminators were putting in the diversity interest. In the world prior to Students for Fair Admission, governments could go to court and say, well, because we want our institutions or our businesses to reflect proportionately our population based on race, based on gender, we need to have these preferences, right? Students for Fair Admission, the court in Students for Fair Admission really put that to rest and said, no, diversity, as great as it is, despite the unique position that higher education institutions were to benefit from diversity, that is not a compelling interest to justify the use of race in treating people differently. And so what the court really laid out that was so important and so useful for us today is that race is rare, that the use of race, rather, is rare, and you can only use it in two very rare exceptions. One, to remedy specific instances of past discrimination, and two, to quell or mitigate race riots in prisons, which obviously is not applicable to educational institutions. But I think if you talk to some students, they will compare their experience to a prison. But nonetheless, those are the instances. Those are the only instances when you can use race to treat people differently. But that doesn't mean, of course, that there's no more work to be done, that the fight is completely over, as the history of affirmative action and government preferences has shown us. Government will continue to push the envelope. Those that want to treat people differently based on race will continue to try and push that legal envelope, just as we've seen in the attempts to overturn Prop 209, to establish ACA 7, et cetera. So one of the lingering questions that I think the courts will begin to tackle, and a fight that will probably take on a little more, is this idea of proxy discrimination that Jack had alluded to. This idea that the government can use race-neutral criteria to benefit the populations that they do want to benefit, using criteria that do just ultimately act as proxies to race or gender, or the things that they want to prefer and benefit. Here's an example of that in play, and actually something that Berkeley Unified has been using for quite a while, and has unfortunately been victorious in challenges against them over this. The use of zip codes. You'll see some school districts across the country assigning students to preferred schools or different schools based on where they live. And they'll use where they live to make those assignments because of the racial makeup of whatever their zip code is. Of course, using that as a proxy for whatever race that they're trying to advantage or benefit. Another thing that the Supreme Court decision talked about was disallowing institutions from doing indirectly what they cannot do directly. And what they were alluding to is the use of the essays in college admissions that would allow people to kind of signal what their race is and have that be used to their advantage by admissions officers that are trying to use racial preferences. So I think what you're going to see more of is the attempt to get around the prohibition on racial preferences through the use of the essays. And I think you've kind of heard stirrings of it already in the UC system. And what I fear is you're not going to get a thorough individual review of students' essays in their applications. What we might find is admissions officers just kind of looking for the keywords that will indicate what the race of the student is, and then give them whatever points gets carried with that racial preference. So what that means is we will rely on all of you and the public to be even more cognizant and be even more mindful of these attempts to get around the ban on racial preferences. This means scrutinizing even more closely what the universities are doing, what the schools are doing, to make sure that they're not using these proxies to get around the ban on racial preferences. And I say all that not to remove the hope and the optimism that we got from Students for Fair Admission. I think what that indicates is we are winning, that universities and educational institutions have to rely on these sort of tricks and gimmicks to get around what the law is, and they have to essentially retreat into the shadows to do what they want to do with discrimination. That means that we are winning, that the victory is on our side, and we just have to keep continuing to push them further and further into the shadows.
I have one quick question. You kind of delineated a prima facie argument against discrimination, but do you think that your examples of success could lead to a kind of a resume? So all you need to do is send out letters where you have this kind of prima facie case of discrimination, and that they would be successful in modifying their behavior and push the energy more into the secondary level, or is this sort of wishful thinking?
Well, certainly various government defendants have taken note of Students for Fair Admissions and PLF's successes in the equality space. So there have been a number of recent examples where we've sent what's called a demand letter to a potential government defendant, telling them that their sort of explicitly race-based conduct is illegal. As an example, we recently threatened to sue the Los Angeles Zoo because they were engaging in racial discrimination in their internship program. They were only opening it up to certain racial groups, which is under the 14th Amendment illegal. And it's also illegal under Prop 209, by the way, because it's a form of government employment. And once we threatened them, they eliminated the program. So as a result of that, I do think that you're going to see it become much more common for government defendants to engage in what Erwin Chemerinsky called unspoken affirmative action, where they try to hide it behind these racial proxies. And it's why this fight against proxy discrimination represents the next frontier of this fight for equality. It's the new front in the war. PLF has a model bill that's aimed at tackling proxy discrimination in public schools, and so we're hoping that as more states adopt that, that'll make it easier to fight proxy discrimination. And proxy discrimination has been illegal under the 14th Amendment since at least 1883, so we're confident that as we get more and more involved with those fights, that we will be victorious, but it's certainly very hard.
Yeah, and just to add to that, and that was the victory against the LA Zoo. That was all Jack, and that was an amazing retreat by the LA Zoo. I think what that exemplifies is this is happening a lot, and unless you call it out, they're going to continue to try and do this sort of thing. Every week, we get dozens of inquiries from the public about cases that they think they might have, about people they want to sue, and I might be understating it. I don't know if it's dozens, it might be more than that. But we review all these public inquiries, and more often than not, unfortunately, some of these don't really lead anywhere. They don't really have a strong case. But I'm encouraged that people are calling us and reaching out with these issues and asking us to look at these, because we can't make change unless people are calling these things out, unless people are mindful of what's going on and are, have that sort of suspicious eye. So, I just want to emphasize again and encourage all of you, if there is something going on, don't be complacent. Let us know what's happening. Let us take a look at it, see if there is something there that we need to take a look at. I think one of the problems we often run into is we do have individuals that have become complacent, especially here in California with all of this. They hear about a grant program or scholarship that is only for persons of a certain race, and they think, well, this is a pretty common thing, and I'm just going to move on from it and accept it and find my own opportunities. Don't do that. In fact, apply for it. If you're not eligible because you're not the right race or skin color, you know what? Apply for it. You just got to do it. I think of the civil rights movement in the 60s, and there was no hesitation for Black patrons to sit in a cafe that said whites only. They sat there knowing very well that they were going to take all of the abuse of violating whatever restrictions were there because of their race and skin color. So, if you have kids who are looking for grants and scholarships when they're applying for college in the next few months, and there is something they're excluded from unlawfully because they don't match the description, I encourage you to encourage them to apply for that. because that's the only way we're going to call attention to this and make real change.
Thank you. So do we have any questions in the audience? Hold on a second. Let me borrow one of the microphones here.
Thanks. Actually, it's 2 points. First, you talked about SFFA involving or preventing government discrimination. The same line of argument in that decision would apply, I believe, to discrimination DEI programs of private corporations. And that would seem to be also a very lucrative field for your organization, for example, to tackle major corporations where they've got these large DEI programs that are discriminating on the basis of race, and the damages claims that would be available might go a long way to helping you continue financing your operations. So are you active at all in the field of dealing with private corporations and watching them stepping on their game?
Our primary focus at PLF is challenging discrimination by the government. That's just our institutional mission, and so that's the niche that we fill. So there are certainly other groups that are involved with challenging discrimination by private corporations, and you are absolutely correct that the SFFA decision does have implications for those sorts of challenges. Justice Gorsuch wrote a very, very nice concurring opinion in that case, where he primarily focuses not on the 14th Amendment issue, because the 14th Amendment only applies to government conduct, but focusing on the Civil Rights Act, and there are various sections of the Civil Rights Act that do apply to private corporations. So if you are worried about discrimination by private corporations, Students for Fair Admission certainly does give you another arrow in your quiver.
And just a second brief comment. It seems that with regard to proxy discrimination, the same line of argument that was used to develop the disparate impact concept and use that as a basis for findings of discrimination, that same approach could be taken to combating proxy discrimination.
You want to take that one, or shall I?
Yeah, quick question. I wonder if you could talk about your discovery process. The University of California, for example, will say that we've got this diversity level, and they say, well, we're not actually using a quota. But obviously, they kind of know if they're doing what they're doing. How do you discover that?
Well, sometimes the defendants are nice enough to just outright tell you that they're doing it. I mean, that's what happened in the Alameda County case, is they said, hey, only, you need to give the 15% of the subcontracting dollars to these businesses, which are minority owned. And if you don't do that, you need to at least show good faith efforts to do so. Otherwise, you're not eligible for government construction contracts. Now, sometimes, as far as proxy discrimination goes, it is less obvious, but sometimes you can still at least get a pretty good feel for whether or not that's going on from the outset. Back in 86, there was a case called Yickwo v. Hopkins, and that dealt with a challenge to a San Francisco law under the Equal Protection Clause that made it illegal to operate a laundry in a wooden building without permission from the San Francisco Board of Fire Wardens. Now, purely coincidentally, all of the laundromats in wooden buildings were owned by Chinese immigrants, or at least the overwhelming majority of them were. And all of the ones in stone and brick buildings happened to be owned by native-born white people. Now, so when it got to the court, they went through, discovery process, and as we'll get to shortly, we do that at PLF as well, where they tried to suss out the actual reasons for the law. And when it got to the Supreme Court said that even though the law was facially race neutral, it was also very, very clearly motivated at targeting Asian Americans rather than, any legitimate health or safety goal in stopping issues with wooden buildings. And that's what we do in the discovery process at PLF too. But we will serve interrogatories and requests for production on the government defendant to try to learn what motivated this decision, why, and frequently, of course, it is motivated toward it does have a racial motive, what they're doing, so we can usually suss that out in the discovery process if it comes to that. And that's sort of how and then we go back and forth on that for a few months, trying to get information from them, and they try to get information from us.
In addition to that, not only are we able to discover information in the discovery process related to litigation when we're not filing lawsuits and filing cases, we very aggressively issue public records requests prior to when litigation is filed. California has a pretty favorable Public Records Act law that allows us to obtain a lot of information that is kept by government at all levels. And of course, at the federal level, we have FOIA, which we also robustly use. And it's a tool that the public can use themselves as well. There's a lot of guides online, actually, and I encourage you to take a look at them that will show you how to file a public records request in California, who to send it to, and what type of language to put in your letters in order to demand these types of things. And we get all sorts of things through that. We uncover a lot of great things that do often lead to some great cases. So the information is out there, just knowing how to get it, whether it's during litigation or before it.
So I was wondering if this case has any relevance to the elimination of standardized testing, for example, at UCs and other universities, and might that be considered some type of a proxy?
Potentially, it depends on the facts of the particular case. But if it was motivated by creating a specific racial outcome, and if they were using standardized test scores, if the test scores correlated with a specific racial group, and they were using that facially neutral factor as a way to try to discriminate against people, yeah, that would create some equal protection concerns.
Are there any other questions?
Yes. There was an article in the LA Times, the information's come out, where the UC said this is the most diverse class ever. I've always felt that the UC didn't get or read the memo called Prop 209 for decades now. And now we're all watching to see the data from the first post-SFA admissions classes at Harvard and in the UC and many other places. So this is the first post-SFA class admitted to the UCs, and they say it's the most diverse class ever, which I think when I see that, I see the UC kind of bragging that they've done the most discrimination ever. And I guess I wanted to go on to say that I feel like since they've been getting away with it for decades, something they've also been getting away with for decades is the eligibility in the local context, which is similar to the zip codes you mentioned. This is one of their mechanisms for disparate impact and sort of hidden discrimination. Anyway, just wanted to bring that up. If maybe you have some comments on it, thank you.
If we were to give the UCs the benefit of the doubt that they're actually following the law, then the other side of it is, well, it's a cell phone, that if it's the most diverse class and they're following the law, then yeah, they never needed racial preferences because they were able to achieve diversity without the racial preferences. But I'm I think more on your feeling and intuition of it that there's something more going on and they're not actually following the law. There was also that article, I think, where in the investigation, I forget who did it, but it was about the med schools. I think it was UCLA Med School. Was it the med school? Yeah, where the dean was explicitly saying, we don't have enough of this race, and we have to discriminate against these other people. And I think that's ongoing, and I'm definitely curious to see how that turns out. But I mean, it's there, it's happening. It's just a matter of trying to root it out.
I'd like to put in a comment here. I do a lot of generative AI in art and also text-based. And I was asking, recently I wanted to have a group of individuals who looked sad. And it came up with the visual representation, they were all white. And so I did it a few times, and the image still came up white. So I figured, well, what if I use the word diverse? Once I used the word diverse, right away it gave racial diversity. So it seems that some of these tropes or images that, or stereotypes that we have are embedded in our language, the way that we use it. And so I don't know whether you say we want more diversity, it just simply means we want more race. So that's kind of a curiosity in terms of traveling the new technology road seems to lead us back to our current problem set. Any other questions? Well, I think it's going to get time for lunch. And when wine?
Ready.
Thank you.